Hi, everyone. Thank you for joining for today's Labor and Employment webinar series. Today we'll be discussing wage and hour best practices. And we are looking forward to spending the next hour with you and talking about some of our favorite subjects. I am joined, my name is Megan Shaked. I am an associate out in San Francisco. I'm joined today by my colleagues, Ashley Mitchell and Samuel Rose. We will go ahead and introduce ourselves and then we will launch into our topic for today.
Hi, everyone. As Megan said, I am Ashley Mitchell and I am based in the Chicago office. I practice in both our labor and employment and OSHA workplace safety groups. I advise employers on a number of matters, including some of the wage and hour issues that we will be discussing later this afternoon.
Thanks, Ashley. Again, my name is Megan Shaked. I'm an associate out in our San Francisco office, and I practice in Carey's OSHA practice, handling primarily Cal OSHA matters, and then, of course, our California labor and employment practice, handling everything from litigation to advising clients on compliance with California law and revising policies and handbooks and things like that. So excited to talk to you about this today.
Hi, everyone. I am Samuel Rose. As Megan mentioned, I am in Carey's Los Angeles office, also supporting both the OSHA and labor and employment practices. With OSHA, I also mainly focus on Cal OSHA being in California, but also support on other inspections and citations around the country. And then in labor and employment, help and advise clients on various wage and hour issues, wrongful termination claims, et cetera. So similar to the practice that Megan does.
All right, so today, while we certainly can't cover every single wage and hour topic in an hour, we will try our best to focus on the areas that we spend the most time advising clients on and that are the most fraught for litigation. And the way I like to think about wage and hour issues is to kind of have these thoughts in your head and to know what things to spend a little bit more time looking at or reviewing, and what issues to kind of keep your ear out for things, since they can cause some challenges down the line. So we're going to discuss independent contractor status. So that's like when is a worker properly classified as an independent contractor versus when they should be treated as an employee. Then we'll be talking about exempt versus non-exempt status. And that comes into play in terms of when an employee might be exempt from various overtime requirements and minimum wage requirements. And then we'll spend a bit of time talking through some miscellaneous wage and hour topics, kind of around the general concept of when employees must be compensated for their work time, and how various kind of iterations of that topic come up in the wage and hour context. Things like, what is compensated time? What are the minimum wage and overtime obligations? And then we'll go over some specific considerations for remote work, since we recognize that many workers are still working remotely at this phase in the pandemic. And then Sam will close us out with some discussion about a collective action trend that is particular to California, the Private Attorneys General Act, which we call PAGA, and whether this is something that how we deal with it in California, and whether this is something that we need to worry about outside of California. So with that, I think Ashley is going to launch us into the discussion about independent contractor versus employee status.
Yep, thanks, Megan. So as Megan mentioned, we are going to start off discussing the independent contractor classification, and we are going to go through sort of the timeline going as far back as September of 2020 into the present day. So in the previous administration in September of 2020, the DOL's wage and hour division announced that they intended the independent contractor classification interpretations to be used by employers, employees, and courts to understand the employer's obligation and employees' rights under the FLSA. And to the extent that there were rulings or interpretations, practices, or enforcement policies that predated the September 2020 announcement, they were going to be inconsistent or in conflict with the regulations and were therefore going to be rescinded. And so in September of 2020, this would have come late during the last year of the Trump administration, and it was in fact a prime target for the then incoming and current Biden administration. And so on the next slide here, we have a timeline of what ensued thereafter. So the Department of Labor published a rule on the independent contractor status under the FLSA on January 7th of 2021. So at the very end of the Trump administration, and the Biden administration delayed the rule on March 4th of 2021, which it then subsequently withdrew on May 6th, believing that that rule as issued by the Trump administration was inconsistent with the FLSA's text and purpose. There were a series of lawsuits that followed the withdrawal of the rule. And in March of this year, a federal district court for the Eastern District of Texas vacated the DOL's attempts to delay and withdraw the independent contractor status under the FLSA rule as issued by the Trump administration. And that court determined that the Trump administration's rule was effective and actually took effect on its original effective date of March 8th of 2021. And so that is the rule that we have today, and it remains in effect. As we can see, the Biden administration is actively working to change that rule. And so on June 3rd, the DOL did announce developing a new rule on independent contractor status. But for the meantime, we are here now with the Trump administration rule, which I will go through those factors that are listed out. So the two core factors, as we can see here, include the nature and degree of the individual's control over their work and the individual's opportunity to earn profits or incur losses based on their own initiative or management. And so the first thing when we think about the nature and degree of their control over their work, we look at things such as their ability to set their own schedules, selecting their projects, the employee's ability to work for others, which might include the employer's competitors. And so in looking at these factors, they weigh in favor of the individual being an employee under the FLSA to the extent that the putative employer, as opposed to the individual, exercises substantial control over those key aspects of the performance of the work, such as controlling the individual's schedule or workload, and or directly requiring the individual to work exclusively for the employer. And this would require the individual to comply with specific legal obligations, satisfy health and safety standards, carry insurance, meet contractually agreed upon deadlines or other quality control standards. And then in looking at the second prong, the individual's opportunity to earn profits or incur losses based on their own initiative or management, while the effects of the individual's exercise of initiative and management of investment are both taken into consideration under this factor, it does not have to be the case that the individual will have an opportunity for profit or loss based on both for this factor to weigh towards the individual being an independent contractor. And so those are the two core factors, but there are three other factors as well. The first being the amount of skill or specialized training required for the work, which the employer does not provide. And this factor weighs in favor of the individual being an employee to the extent the work at issue requires no specialized training or skill, and or the individual is dependent upon that putative employer to equip them with any skills or training necessary to perform the job. The second of the additional factors is the degree of permanence of the working relationship between the individual and the putative employer. And in looking at this factor, it weighs in favor of the individual being an employee to the extent that the work relationship is instead, by design, indefinite in duration or continuance. And then the final factor is whether the work is segregable from the potential employer's production process. And this factor is different from the concept of the importance or centrality of the individual's work to the putative employer's business.
Thanks, Ashley.
And so I think, yes.
Go ahead.
Oh, sorry. And so I think next we look at how these factors compare to the ABC test, which is something that is also used in California.
Perfect. Thanks so much, Ashley. Nice segue. So as comparison to what Ashley discussed, the test and control, or excuse me, the factors that are considered under the federal the FLSA states, in contrast, many of them follow what's commonly known as the ABC test. And I'll just discuss California's ABC test as an example. And California has gone through an interesting evolution in how it has assessed independent contractor versus employee status, because for years and years, going back to, I believe, 2011, California applied a multi-factor test under a California Supreme Court case known as Borrello. And so there was no one factor that was determinative. It was really balancing and looking at all of the factors, which had some of the similar concepts that Ashley mentioned, you know, the degree of control, whether they're using their own tools, whether they're controlling their, you know, the work that they're performing and how they're performing it. In contrast to that, in 2018, the California Supreme Court came out with this dynamics decision, and this had an ABC test where there were, in order to be properly classified as an independent contractor, an employer had to establish 3 factors. And this was eventually codified into California Labor Code through an assembly bill that came down in 2020. And so under this test, a worker who performs services for hire is an employee rather than an independent contractor, unless the employer can establish all 3 of these factors. So the worker has to be free from the control and direction of the hiring entity. The worker has to perform work outside the usual course of the hiring entity's business, and this is often the most challenging factor to establish. And then 3, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So when the dynamics decision came down and then AB5 came down, there were a lot of concerns about employees who may have otherwise been properly classified, workers who may have been properly classified as independent contractors under the Borrello test could no longer be properly classified as independent contractors because they couldn't meet the test under this ABC test. So as you can imagine, there was a lot of lobbying efforts to create some carve-outs from the ABC test requirement. And we have seen legislation over the last few years that has passed that have established various exemptions or exceptions from the ABC test that are for certain kinds of business relationships or certain kinds of professions. And they are very numerous and they are very detail oriented. But what they do essentially is they kind of take a worker out of the ABC test. And oftentimes, if you meet the requirements for the exemption, then the analysis becomes more of a Borello analysis, where you're assessing a multi-factors, and you're looking at whether the employee truly is an employee or whether the worker truly is an independent contractor. And the issue of properly classifying workers for this purpose is important, because if you misclassify an employee as an independent contractor, then there are all of the kind of wage and hour benefits that come from being an employee are potentially out of compliance, right? So if you have classified somebody as an independent contractor, but they're really an employee, then you could be under obligations, if they're an exempt employee, which we'll discuss in a little bit, to pay them minimum wage, to pay them overtime, to make sure they're getting their proper meal and rest periods, and to comply with the numerous other wage and hour obligations that are afforded employees. So of course, the risk of misclassification is civil lawsuits, state agency proceedings, which could be both in terms of the misclassification from a tax standpoint, right, not paying employment tax, but also a state agency proceeding from perspective of the actual underlying wage and hour violations, right? So a claim to the labor commissioner, for example, that a worker wasn't paid overtime. Third-party personal injury lawsuits could come up for independent contractors, depending on the correct relationship. And then there's potential PAGA liability, which Sam will talk about a little bit later. And other than the third-party personal injury lawsuits, the consequences of, or the potential for civil lawsuits, state agency proceedings, and PAGA liability is really the same for many of the for the other wage and hour issues that we'll discuss throughout this webinar. So it's something for employers to review if necessary, in order to make sure that their workers are being properly classified. And audits for proper classification is something that are often done to make sure that those workers are being properly classified. So I alluded a bit to exempt versus non-exempt status. So now we're going to launch into discussion about what we're talking about here and what the implications are for treating an employee as exempt versus non-exempt.
Thanks, Megan. So as Megan mentioned, the FLSA does have exemptions. There are two kinds of exemptions for employees: those who are exempt from both the minimum wage and overtime requirements, and then employees that are only exempt from the overtime payment requirements. And so first, we are going to look at the test for employees that may be exempt from both the minimum wage and overtime pay requirements, starting with the salary basis test. Under the salary basis test, it requires that an exempt employee be paid both on a salary or fee basis and at a rate at least equal to the standard salary level, which today, right now, is $684 a week. We will discuss later in today's webinar what some of the proposed changes are, and one of the proposed changes is, in fact, raising that standard salary level, but for today, right now, it is $684 a week. And when we say that an employee is paid on a salary basis, that means that the employee must regularly receive each pay period on a weekly or less frequent basis a predetermined amount that constitutes all or part of their compensation. That predetermined amount cannot be subject to reductions because of variations in the quality or quantity of the employee's work. And for employers that do make those deductions, they will lose the salary basis exemption for that pay period where the improper deductions were made. And other employees, this is important to note, in that same job classification, working for the same managers that were responsible for the deductions, also lose that salary basis exemption for that same pay period. Now, this is not to say that you cannot make proper deductions under the salary basis test. And so examples of proper deductions would be deductions that are required by law, such as the payroll taxes, full day absences for personal reasons other than sickness or disability, including vacation, and full or partial day absences that are covered by the FMLA. When we say under the salary basis test that an employee is paid on a fee basis, that means that the employee is paid an agreed amount for a single job, regardless of the amount of time it takes the employee to complete the work. And that fee is paid at a rate based on the hours actually required to complete the work that would equal at least the minimum weekly salary, which is now $684 a week, if the employee works 40 hours at that rate of pay. Okay. Next, we will start to look at those duties tests. The duties tests require that an employee receive the minimum FLSA compensation requirements and that the employee's actual job duties satisfy the primary duty requirement for the particular exemption. It is important to note here that the employee's actual duties and not their job title is what makes the determination. And so the employee's primary duty is based on the principal, main, major, or most important duty that that employee performs. And so looking at the duties test, we will first look at the executive exemption. This is to be exempt, the executive's compensation must satisfy that salary basis test that we just discussed, and specifically the salary basis piece of it, unless the employee is an exempt business owner. So remember, the salary basis, they could be paid on a salary or fee basis, but under the executive exemption, the fee basis option does not qualify. So it does not qualify for the executive exemption. And then looking through the primary duties, the employee's primary duty must be the management of the business, and the employee must regularly direct the work of at least 2 or more full-time employees and have the authority to hire and fire other employees, or it must be the case that their recommendations for hiring, firing, advancement, promotion, or any other status change must be given significant weight. Turning next to the business owner's duty test. Business owners are exempt under the executive exemption, and for this to be the case, the business owner must own at least a 20% equity interest in the business and be actively engaged in the management of the business. Turning next to the administrative exemptions under the duties test. Here, the employee's compensation must satisfy the salary basis test that we talked about previously, and their primary duty must be their performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers, and the employee must have the ability to exercise discretion and independent judgment on significant matters. And then turning next to the professional exemption. Here, the employee's compensation must again satisfy the salary basis test unless that employee is a teaching professional, a licensed and practicing attorney or physician. And here, their primary duty must be the performance of work requiring advanced knowledge or a creative professional. And when we say advanced knowledge, that means work that is predominantly intellectual in character and work that includes the consistent exercise of discretion and judgment. And so that knowledge must be in a field of science or learning, and it must be the type of knowledge that is customarily acquired by a prolonged course of specialized intellectual instruction. And then just looking at the creative side, a creative professional's primary duty must be work that requires invention, imagination, originality, or talent that is in a recognized field of artistic or creative endeavors. And then turning to the outside sales exemption, here the employee must have a primary duty that requires the making of sales, and it must be the case that the employee is regularly away from that employer's primary place of business. And then under our final category of exemptions for both minimum wage and overtime pay, we turn next to the highly compensated individuals. And for here, the highly compensated exemption applies to employees that earn an annual compensation of $107,432 or more annually. And this would include at least the $684 a week paid on the salary or fee basis. And so now we're going to turn to our overtime only exemptions. As we can see, there are two of those: commission retail sales and the Motor Carrier Act. To qualify for the commission retail sales exemption, the employee must meet the following conditions. It has to be the case that the employee is employed by a retail or service establishment. Their regular rate of pay is more than 1.5 times the applicable minimum wage, and the work weeks where that employee would be working overtime, applicable minimum wage, meaning the greater of the federal, state, or local minimum wage, and more than half of the employee's total earnings in a representative period consist of their commission. And then last, but certainly not least, the Motor Carrier Exemption, which applies to employees that are subject to the Motor Carrier Act. And it has to be the case that the Department of Transportation has the authority to establish qualifications and maximum hours. And so I'm sorry, I know that we've given you a lot, but just if you remember at the beginning of discussing the salary basis test, we mentioned that the DOL is trying to make changes. And so on our next slide, we encourage employers to be prepared for rulemaking to begin at the very latest, the end of this year. As mentioned at the end of last year, the DOL did announce its plan to revisit the salary threshold for white-collar employees and has steadily worked towards that goal this year. In fact, just last month, on July 5th, the DOL sent its new proposed rule to the White House Budget Office for review. And this is, in fact, the last step before that proposed rule is released to the public. The review process can take up to several weeks, but as last we checked, the Budget Office did not have any scheduled stakeholder meetings after last week. So employers should definitely stay tuned for what the Biden administration hopes will be an update to that salary basis test. And so the implications of these revised exemptions, we are speculating that these changes that will come, they will be at a significant cost to employers, meaning a significant increased cost both for increased overtime payments and just the general expense of restructuring and classifying employees and employee positions. And so although the revised rule may benefit employees in the end, these changes also pose potential drawbacks for employees, as some employers may have to decrease the size of their workforce based on the higher cost. But in looking forward and thinking about the potential changes, employers would be well advised to save on later expenses. They should continue to evaluate exempt classifications for their current workforce or for your current workforce to ensure that you are meeting the minimum current requirements for the white collar exemptions, and then pay special attention to employees who are close to the salary threshold and those who hold an assistant manager or supervisor type position. These audits are especially useful when they are guided by in-house counsel or outside counsel, as the current exemptions are quite complicated. I know I went through them pretty quickly, but they are quite complicated. And as Megan mentioned, the risk of misclassifications can be quite costly. In fact, just at the beginning of this week, a federal judge in Pennsylvania ordered a staffing company to pay $2.5 million in unpaid wages and liquidated damages for its failure to pay employees overtime. So just keeping in mind that while the tests are complicated, it's definitely worth the while and the time to go through and make sure that employees are currently classified correctly, and then paying especially close attention to any updates and employees who are currently classified correctly but on that salary threshold and may no longer qualify depending on the new rule.
Thanks, Ashley. I
Turning-
definitely echo those sentiments from the California perspective. Just as a point of comparison, California has exemptions from both minimum wage and overtime and overtime only exemptions, and has similar, the white collar exemptions that Ashley discussed, such as executive, administrative, professional exemptions, and then has others that are provided both in through wage orders and in the California Labor Code. And here, generally speaking, the exemption that imposes a higher standard is going to be the one that applies. And even if an exemption sounds like it's the same under the FLSA and under California law, the requirements might not be entirely similar once you actually dig into all of the detail, because as Ashley mentioned, these are highly fact-specific inquiries. They get into, what the worker is doing and how much time they're spending doing the various tasks. And you really have to dig in to be able to thoroughly consider whether an employee is properly being treated as non-exempt. And another thing to keep in mind is that in California, since the salary basis is based on the minimum wage requirements, since California's state minimum wage requirements are much higher, that salary basis is going to be much higher in California. So to the extent you have any workforce that might be covered under the FLSA and or California or other state law, that's something to take into consideration as well. Okay, so I will continue to launch into kind of the areas while we certainly spend time doing audits for proper classification of independent contractor versus employee, and certainly do many audits to analyze whether a worker is properly classified, classified as exempt. The next kind of topics are what I often spend working on a daily basis. So the first concept I want to kind of go over is just generally speaking, what is compensable time? It seems like a pretty straightforward question to answer. Employees have to be paid for hours worked, but sometimes what that actually means does differ depending on where you are. And so California and the FLSA have definitions of hours worked. And sometimes when you are really getting into the details of what that means and how that applies to various circumstances, the answer ends up coming out differently. Just an example that I can think of off the top of my head is things like travel time. Sometimes whether travel time needs to be compensated or not is analyzed differently based on how hours worked is defined under federal or California law. So we're starting out from the general concept that employees in general must receive at least the applicable minimum wage, and that unless they're exempt from overtime wages, they may also be entitled to overtime wages. And the way that working time is applied oftentimes is, it's maybe straightforward if somebody is clocked in and working on the task that they are assigned to perform. But some of the stickier issues are raised kind of around the edges, where you might have somebody who is waiting to start a task, but they are on site ready to go, but they're not yet performing the task they're hired to perform. Or they may be on call. They may not even be on the premises, or they may be on the premises, but they're waiting to be called to work. Travel time I mentioned, and then also meal and rest breaks can really vary depending on where you are. Meal and rest breaks is a huge issue in California. And just as comparison to the FLSA, hours worked, which focuses on, time during which employees suffered or permitted to work. California uses similar language, but it also includes the concept of an employee being subject to the control of the employer. So that sometimes makes a difference in cases where travel is provided by the employer and the employees, don't have control over that. that time. Maybe they're asked to arrive at one location and then they're, transported by vehicle to a site where they're performing their task. So that's kind of how the difference sometimes plays out. I know Ashley and I are kind of playing tennis a little bit, going between the FLSA and the California issues. So I don't want to talk over her at all, and I'll let her chime in on the concept of de minimis rule, how that plays out on the federal side, and then I'll give the California take on that in a minute or two.
Thanks, Megan. So yeah, let's first take a look at the de minimis rule under the FLSA. So in recording work time under the FLSA, infrequent and insignificant periods of time beyond the scheduled working hours, which cannot or could not, as a practical matter, just be precisely recorded for payroll purposes, typically do not need to be compensated. These are what we are talking about when we say the de minimis rule. It's those scheduled working hours that would just be really difficult to precisely record. And under the FLSA, this type of time, or this sort of time, employers typically don't have to worry about paying. It's not a big issue. And I know that it is something radically different in California, so I will allow Megan to speak to that.
Thanks, Ashley. Yeah, so in 2018, the California Supreme Court spoke very clearly on this issue and declined to apply the FLSA's de minimis rule. So they held that employers must compensate workers for all reasonably measurable time worked, even if it was for small durations. So in that case, you had a former Starbucks shift supervisor who alleged that he was required to clock out before he started his closed store procedures. And that those closed store procedures, if you've ever seen a Starbucks at closing time, you can imagine, the last bag of trash has to be taken out to the dumpster on the way out the door, that those tasks took between 4 and 10 minutes. And that, and the court held that although California had, a de minimis rule that, in principle, perhaps, that it did not apply here. And it was not, the wage orders in California did not allow employers to require employees to routinely work for minutes off the clock without compensating them. So California Supreme Court was very clear that all hours of work, no matter how minimal, no matter how difficult to capture, if that's regular work, that needs to be captured and it needs to be compensated. Meal and rest periods is also an area that we spend a lot of time advising on. In California, meal periods, there's a meal period requirement, and it has to be for employees who work more than 5 hours of work. They have to be provided with a meal break of at least 30 minutes. And then if they work more than 10 hours, there's a second meal period. And there are some exceptions there's an allowance for a waiver in certain circumstances. For example, if an employee works no more than 6 hours, they can waive that first meal period. Or if somebody works, is eligible for their second meal period, they can waive one, or they can waive one as long as they take the other one. And then rest periods in California have to be paid, and those have to be provided essentially 10 minutes for every 4 hours worked or major fraction thereof. So there's really specific guidance through California, a big California Supreme Court decision called Brinker that provides a lot of helpful information about employers' obligation with respect to meal and rest periods. And this is really fraught for litigation in California because although the rest periods are paid, if employees are not provided their rest periods as required, then there is a premium pay penalty of up to 1 hour per day for missed rest periods, no matter how many rest periods might have been missed. For meal periods, even though meal periods are generally unpaid, although there are certainly circumstances where meal periods have to be paid, even if an unpaid meal period, even if we're talking about an unpaid meal period, if there is a violation, for example, the meal period isn't given on time, it has to be provided within a certain amount of time once the employee has been working, or it is interrupted, or it's less than 30 minutes, or it's somehow otherwise violating the law. For example, an employee was on call during their meal period, or they were required to be on the premises. Then again, there is a 1 hour of premium pay that is tied to that violation. So California meal and rest periods is a really big issue to be on the lookout for if that's applicable. And then Illinois also has a meal period requirement of at least 20 minutes, and there are certain circumstances where that meal period must be paid. And that is, similar concept to in California, that the Illinois meal period has to be paid if the time is spent predominantly for the employer's benefit. Another kind of unsuspecting issue for paid time is break time for nursing mothers, which, states don't necessarily require that the lactation breaks be paid. However, if the lactation breaks are taken during a paid rest break, then those would become compensable time. So for example, in California, the way the lactation break rules work is you're encouraged to take the breaks during your paid rest breaks. So then those breaks become paid as well. Let Ashley jump in on getting us started on our overtime discussion.
Thanks, Megan. So, just as a preview to our overtime discussion, just so we're all on the same page, employees that work more than 40 hours in a work week must be paid at least 1.5 times their regular rate of pay. And of course, there are the exceptions that we talked about previously. So the exemptions from overtime pay for individuals that are employed as bona fide executive, administrative, or professional employees that receive that salary basis of at least $684 a week. These are those white collar exemptions that we have discussed and are a little complicated. So definitely reach out if you guys have some questions about that.
Thanks, and just wanted to flag, we want to make sure we can get through everything. So I'll go through this quickly, but just to flag, some people forget that California overtime is not just based on, the threshold of 40 hours a week, but that there's also a daily overtime requirement in California. It's 40 hours in 1 week or 8 hours in a day. And beyond that, there's specific requirements about how and when overtime needs to be paid. The regular rate of pay is a very interesting issue because it can get into some very complicated math. So I'll let Ashley kind of highlight the issue, and then I'll talk about the difference in California.
Thanks, Megan. So effective in January of 2020, so a little while ago, the DLL updated its regulations governing the regular rate requirements under the FLSA, and this was the first time it had done so in over 50 years. These updated requirements define what forms of payment employers can include and exclude in the FLSA's time and 1/2 calculation when determining those overtime rates. Before this update, employers were left a bit uncertain about the role that perks and benefits played into that calculation. But this new rule provides clarity on which perks and benefits must be included in the regular rate of pay, as well as which perks and benefits, can be excluded. And so the department clarifies to confirm that employers may exclude the following from an employee's regular rate of pay. So these are the exclusions. including the cost of providing certain parking benefits, any wellness programs, any on-site specialist treatments or gym and fitness access in classes, any discounts that employees may receive on retail goods and services, those tuition benefits that employers may be offering, whether they're paid to an employee, the education provider, or student loan program, any payments for unused paid leave, including paid sick leave or paid time off. Another exception is payments of certain penalties that are required under state and local scheduling laws. Any reimbursed expenses, this might come up especially now with the use of remote work. So expenses like cell phone plans, credentialing exam fees, organization membership dues, and travel, even if these expenses are not incurred solely for the employer's benefit. Certain sign-on bonuses and certain longevity bonuses, the cost of office coffee and snacks that employers may provide to incentivize employees who are returning to the office as gifts, those discretionary bonuses, and contributions to benefit plans for accident, unemployment, legal services, or other events that could cause future financial hardship or expense. The final rule also includes additional clarification that the label that's given to the bonus does not determine whether it is discretionary. And so that is also something to keep in mind as you think about calculating the regular rate of pay under the FLSA.
Thanks, Ashley. And under California law, there are similar concepts in play. So the regular rate of pay for overtime purposes, you can't simply take an employee's regular hourly rate and apply that to overtime. You have to consider whether there are any other forms of compensation that need to be included in the calculation and coming up with that overtime rate, and if there are any particular categories that can be excluded. And that California, as you can imagine, has weighed in on many of the same kind of categories that Ashley discussed. And it's something that you would want to look at really carefully to see if any of those categories will apply based on the compensation that a company is providing and whether that rate needs to be changed. Another significant decision that came out of California clarified that the regular rate of compensation for meal and rest period premium pay, which is what I mentioned, the payment that needs to be made if there's a violation of meal and rest period requirements, as well as recovery time, which is essentially rest break in certain high exertion contexts, that the rate that's paid for that purpose is the same rate of pay as for overtime purposes. So it is going to be potentially that higher rate. Just to flag some of the other wage and hour issues that we see, particularly in California, are claims stemming from the wage statements, which are subject to very specific enumerated requirements under the labor code. Section that applies. Issues of timely pay, not only in terms of whether paydays are following labor code, California labor code requirements, people have to be paid within a certain amount of time from the work that they perform, but also timely pay in terms of commission and timely pay upon termination. Differs in California whether somebody gives an announcement that they will be leaving in 2 weeks versus somebody who gives no notice, or somebody who is terminated by the employer. And then also thinking through various record keeping requirements and what documents might need to be maintained and for how long. So we just want to apply some of these wage and hour concepts in the context of telework, because we recognize that many employers have continued to give employees the option to continue to work remotely. And when the pandemic started, we discussed how these wage and hour issues can play out when you have employees who are working from home. And certainly, knowing how and when employees are working is really important. And some businesses we recognize may not have been accustomed to tracking employees' hours or ensuring they're taking, their necessary breaks, because it was happening, face to face in person in an office, and it was much easier to make sure that those things were happening. So employers have had to adjust and potentially implement a policy to address all of these issues and kind of speak on it more directly. And one way to do that, if this continues to be a topic or an issue for employers, is to have a more robust telework policy that sets out the expectations and the responsibilities, and it can address everything from which positions are eligible for telework, what the expected work hours are, how employees are expected to report their hours of work, or otherwise abide with other, requirements to report overtime, or even some employers' policy require that overtime be approved before an employee works at overtime. So emphasizing any policies that might, affect remote workers in a different way. And then something to really think through are reimbursement issues. FLSA requires businesses to reimburse workers when necessary expenses push their pay below minimum wage. And then some states, California has a specific reimbursement statute that requires reimbursement for necessary business expenses. And so again, those things are sometimes easier to catch when you're in an office with somebody and you see that they, have a new accessory for their computer or whatnot, but it's harder sometimes to be tracking those things for remote workers.
And if I may, Megan, sorry, just one quick note for those employers that are covered under the FLSA. In consideration of remote work, the Department of Labor did issue a field assistance bulletin. And as Megan emphasized, it's really important to have those policies clearly delineated, and where they are, at least under the FLSA, employers are not required to take impractical steps to identify any unreported work if employees are not using the available reporting procedure and the employer is not otherwise notified of the additional work time. So just wanted to point out, at least under the FLSA and that DOL field bulletin, if the policies are clearly delineated, employers don't have to jump through unnecessary or extensive hoops to really determine when employees are engaging in off-the-clock work.
Thanks, Ashley. So just to kind of go over some additional considerations, tracking hours worked is as important for employees who are working, for non-exempt employees working inside a office, in-person work environment, as in a remote work situation. But certainly if you don't have a system to track hours worked for non-exempt employees who may be working remotely, that's something to consider. And also considering a system for ensuring meal and rest breaks are being properly provided if that's required in your jurisdiction. Particularly in California, we worry about meal and rest periods being interrupted, and then that being a violation that is not caught. So there are ways to train and audit meal and rest break practices to make sure that employers are meeting their obligations. We discussed having policies in place and good communication for reimbursing workers for reasonable business expenses. And, all of this kind of raises a good reminder to consider regular revisions if necessary, or at least review to handbooks and policies that might address these various wage and hour issues, conducting trainings if necessary. We see this really helpful in if you have a workforce that's really susceptible to meal and rest break violations. and just general audits of wage and hour practices. And with that, I will turn it over to Sam to discuss our last topic of the day, which is the collective action trends in PAGA in California.
Thanks, Megan. So I know we've covered a lot so far in this presentation. It's all very important, but we want to make sure we cover this last issue, which is, at least for now, isolated to California. It's pretty complicated, but we will go through just the basics now, as I know we're running out of time. I know you guys have things you got to go back to, but PAGA stands for the California Private Attorney General's Act. It was passed in 2004 in an attempt to ensure that state agencies could enforce California labor code violations. And basically what it does is it allows a single employee to file a lawsuit to recover civil penalties, which would otherwise only have been recoverable by the Labor and Workforce Development Agency, that's LWDA. And the penalties are set by statute for most violations, but when there is no statute on point, the penalty is generally $100 for each violation per employee, and then $200 for subsequent violations. So you could see how, because it's per violation and per employee, these violations can add up extremely quickly. And the penalties for these violations are in addition to civil remedies for each type of violation and attorney's fees. So the financial obligation on the employer can rise extremely quickly. And that's why these are so important to discuss. Next slide, please, Megan. Thank you. So these are the different aspects of PAGA. There hasn't been, because it was just passed in 2004, and there's not really any law like it. There's not a lot of case law on standing because it's so new. But for now, as long as a PAGA plaintiff has suffered a single violation, they can bring any violation that any other aggrieved employee has suffered, even if the PAGA plaintiff hasn't suffered that same violation. So you could very quickly get a lot of plaintiffs, or at least representative actions, involved in a PAGA case. And as I mentioned earlier, these penalties are in addition to other remedies. So, for example, if an employee is entitled to premium pay for a meal period violation, they're entitled to that premium pay and the PAGA penalty. The PAGA penalties don't preclude that recovery under the labor code. So just another example of how these liabilities can increase pretty quickly. And then just a note on the 1-year statute of limitations, that limits the claims that can be brought against the employer. But if the employer doesn't ensure that their policies and practices are enforced, you could have new claims constantly arising under a new statute of limitations. So it could just be this continuous cycle of PAGA claims. And that's something you definitely want to try to avoid. Next slide, Megan. So other states have considered a similar law, although no state has actually passed it. So California is pretty unique in this way, but these states, Connecticut, Illinois, Maine, Massachusetts, New Jersey, New York, Oregon, Vermont, and Washington have looked at various different aspects of PAGA and considered whether to implement that in their state. So there's nothing outside of California right now, but if you're in these states, just keep an eye out in case some type of legislation eventually does pass. The last topic we'll cover on this is how PAGA relates to arbitration agreements. So since 2014, California employment arbitration agreements were analyzed under a case called Estanian. But this year, the US Supreme Court altered that whole landscape by issuing a decision in a case called Viking River. Basically, what Viking River says, it's a complicated decision, but in a high level, is that when there is a valid arbitration agreement in place, employers can enforce that agreement against individual claims under PAGA. So if you take the representative plaintiff who has an arbitration agreement, you deprive their standing of bringing the representative claims. And so there is no type of PAGA claim to bring anymore because that plaintiff has now been ordered to arbitration. This is opposite of what we expected the California legislature to interpret this law as. So we expect they will quickly act to counter this decision. But just best practices for right now, employers should review their arbitration agreements, specifically any clause that has to do with waivers of PAGA or class or representative actions. And also consider redrafting their arbitration agreements to withstand any future changes in the PAGA statute, since we expect that the California legislature and or the Supreme Court will weigh in on this issue again. And that way you avoid having to redraft these arbitration agreements after every change to PAGA. So that covers our brief discussion of PAGA. Obviously, if there are any questions or anyone needs any clarity on any of these issues, feel free to reach out to us after the presentation.
Thanks, Sam. We certainly, it's difficult to cover so many different wage and hour topics in a short period of time. And there's certainly a lot of nuance in all of the applicable laws, and we could discuss wage and hour topics all day. But we will wrap up for now. Hopefully that was an interesting discussion and kind of got you thinking about some of the things that we most commonly deal with on the wage and hour front. Excuse me. I'll just go over a few more kind of concluding slides so that you know what we have in store for the rest of our 2022 Labor and Employment webinar series. We have 4 more to go, so if any of those topics are of interest to you, be sure to tune into those. We also have a number of different blogs that we are active in. We keep updating, particularly with all of the changes and the specifics and the nuance of California law. We like to get things posted on that employer defense report. That's the blog that has our labor and employment updates. And then for those of you who are needing your SHRM credit, feel free to reach out. If you need any specific information, you can contact Teresa Green. Her email is at the bottom of the slide if you need the code. But just a reminder for you to get that information if you need it. We are certainly, as Sam said, we're certainly happy to answer any other questions. Oh, excuse me, I went too far. Answer any questions you may have. It was nice to spend the hour with you, and here's all of our information. And thank you so much for your time today.